There is a sentence written into the Constitution of the state of Michigan. It was put there in 1963 deliberately by people who wanted to make a promise that could not be broken. It says that the pension benefits of public workers are protected, not should be protected. For 50 years, every police officer, every firefighter, every water department clerk in Detroit understood exactly what that meant. Your retirement is not a company policy. It is not a handshake. It is written into the Constitution of the state you serve. Nobody can take it. On the 3rd of December 2013, a federal judge in a courtroom in Detroit explained why that was not true. He ruled that pensions, like any other contract, can be cut, and that the constitutional protection those workers had trusted was not a bulletproof shield in bankruptcy. In the gallery sat retirees living on $19,000 a year, police officers and firefighters who had never paid into Social Security because they were promised. This is the story of what happens when the strongest promise a government can make meets the moment there is no money left to keep it. And the most unsettling part is not that somebody cheated. It's that, by the end, almost everyone involved was trying to do the right thing. To understand the weight of what was at stake, you have to understand who was on the other side of that promise. The average annual pension for a retired police officer or firefighter was around $32,000. For most other retired city workers, it was $19,000 to $20,000 a year. Detroit's police and firefighters had not paid into Social Security. If the city pension shrank, there was no federal floor underneath them. No backup, nothing. Many of them were already poor. They could not manage without that check, and if it were meaningfully cut, some of them faced actual destitution. Detroit itself had been dying for decades. The population had drained away hundreds of thousands of people gone, taking their tax payments with them. The industrial base that built the city had moved or closed. Whole neighborhoods stood empty. By 2013, Detroit was carrying $18 billion or more in debt. Its two pension funds were short by an estimated $3.5 billion. In March of that year, Michigan Governor Rick Snyder appointed an emergency manager named Kevin Orr, handing him extraordinary authority over the city's finances. 4 months later, Orr and the governor concluded there was only one option left. In July 2013, Detroit filed for Chapter 9 bankruptcy protection, the largest municipal bankruptcy in the history of the United States. In the American legal system, when federal law and state law conflict, federal law generally wins. For 50 years, that conflict was theoretical. It stayed theoretical because no major American city had ever actually gone bankrupt in a way that put it to the test. Retirees and unions argued their pensions were protected. Protesters carried signs outside the courthouse. About 30 people stood on the steps, arguing that retirees' rights had been violated. And then Judge Stephen Rhodes ruled. He found that Detroit was insolvent and eligible for bankruptcy. And on the pensions, he made the finding that shook public employees across the country. In a federal bankruptcy, contracts can be impaired. Rhodes' ruling suggested that the protection was conditional, that it held right up until the moment a city ran out of money. It is a lock on a door that opens when the fire starts. The bond insurers pointed out they were in the same legal class as the pensioners. They argued that sentiment has no place in a courtroom. They wanted the city's art sold so they could recover more. It is a cold argument. It is also, legally, not a stupid one. Then came the strangest turn. Detroit owned the collection of the Detroit Institute of Arts, potentially worth billions. Creditors wanted it sold. The idea of a bankrupt city auctioning off its masterpieces drew reporters from as far away as France. What emerged instead was called the Grand Bargain, $816 million pledged by foundations and the state to patch the pension funds and keep the art off the auction block. And then the retirees had to vote on it. That vote is the quiet cruelty at the center of this case. The choice was not accept cuts or keep your full pension. The choice was accept this deal or the outside money may vanish and the cuts will be far deeper. The retirees voted yes. On the 7th of November 2014, Judge Rhodes approved Detroit's plan to exit bankruptcy. The case had run just under 16 months, lightning speed by the standards of a bankruptcy this size. General retirees had their pensions cut by 4.5% and lost their annual inflation adjustments. A fixed pension without an inflation adjustment shrinks in real terms every single year, quietly, forever. In the long run, losing the escalator hurts more than the cut. Judge Rhodes said, "The outcome borders on miraculous." Foundations and the state had put up millions to shield them. Compared to what could have happened, this was a rescue. But retirees pointed out that about 80% of the settlement came from them. They described it as a transfer of benefits toward bonds for new projects. They voted for the least bad option available. Both things are true. Detroit did not end with Detroit. The ruling created a precedent that a state constitutional protection for public pensions may not survive contact with federal bankruptcy. Rhodes himself would go on to advise Puerto Rico, facing debts exceeding $105 billion. In the end, there is only ever one real protection. Not the promise, the funding behind it. Everything else is a sentence on a page, waiting for the day someone finally reads it in a courtroom. Next on Paper Trail, a hedge fund manager took over one of America's greatest retailers and then sold its best pieces to companies he also controlled while the stores went dark.